We're here from the raw beauty of the American Middle West, bringing you the legal legends of the Hoosier State, brought to you by the Indiana Trial Lawyers Association. A podcast where we explore the lives and careers of those who helped found the Indiana Trial Lawyers Association and grow it into what it's become today. We'll visit with our guests and plumb the depths of their career path, where they've gone and where they've taken their career, and Indiana law along the way. So sit back and set the gear shift to the high gear of your soul. Get ready to talk with one of the legends of the Hoosier State. I'm your host, Joe Williams, and we're blessed enough to be here today with our guest, Roger Pardieck, at his home in Columbus, Indiana. Roger, how you doing today?
I'm doing fine. How are you?
I'm doing pretty well. I have to say, this place is gorgeous.
Thank you.
I would never... if you ever tried to work from home around here, you'd never get anything done.
That's right. It's not conducive to hard work.
Well, why don't we let's go back. Tell us a little bit about how you started your career. Why law, and what kind of steered you towards plaintiffs cases specifically.
The circuit judge in Jackson County called and said that he had heard that I was graduating from law school and would I be interested in serving as prosecuting attorney. I told him no, that I really intended to go into international law, and I was looking at Eli Lilly as a possible source of employment, and so I turned him down. 6 months later, he called again and said they still hadn't found anybody to fill that job, and would I want to reconsider it? And I told him I did not want to. My dad, he said, I think he said I could do it for like 6 months or a year and something like that, some time limit. And my dad suggested I might want to consider that so I would get a chance to try a lawsuit. Mm-hmm. If I go to work for a corporation, I would never try a case. So I called him back and explained why I was calling and told him I'd give it a try. And I did. And he said, "You have a trial in 2 weeks." And I said, "Oh my God, that's not possible." I had never tried a case before. I had no idea what I was going to do. And I tried the case in 2 weeks, and I didn't know what I was doing. The jury was out for 20 minutes, and the defendant was acquitted. And I walked out of that and learned that I had another trial in another 2 weeks. And so I prepared a little better for that one. Mm-hmm. Had some help, some suggestions from the judge, and the jury was out for 13 hours, and he was convicted of first-degree burglary. And the defendant was a guy that I played junior legion baseball with when I was in high school. So I convicted one of my best friends, although he wasn't a best friend anymore at that point.
Well, not when he started burgling.
So that was the introduction.
So what changed between the first trial and the second trial? You know, it sounds like you bombed on the first one. It sounds like you crushed it on the second one. What changed?
I didn't know what I was doing the first time.
So in 2 weeks, you figured it out?
Well, I had some help, and I had some help from the judge, who explained a few things to me about what I did wrong and what might be helpful, and prepared a little differently. So
okay. So
it's easier.
So you start out as a prosecuting attorney. What got you to be a plaintiff's lawyer?
I had a couple of civil trials, and they were all right. They were a little boring compared to being prosecuting attorney. Then I had a chance to try a couple of relatively minor personal injury cases, and that just really turned me on. I loved it. Mm-hmm. And I enjoyed the medicine, enjoyed the experts, enjoyed working with the state troopers. Just the whole thing was just suited for me.
And so approximately what year did you make the transition?
Oh my. Probably 1961.
Okay. And so were you in Seymour at the time?
No, I was living in Bloomington, and I had the intention of moving to Indianapolis, and I drove back and forth for the first two trials, and after the second trial, I realized that I wanted to do more of that, so I then moved to Seymour,
Okay.
and so
What pulled you to Seymour?
that's my hometown.
Okay.
My family was there,
Okay. Okay.
so
So
I had a free place to live.
So when you started doing plaintiff's work in the 1960s, was there an American Trial Lawyers Association?
No, there was not. There was something called NACA, National Association of Claimants Counsel.
Okay.
That ultimately became ATLA.
Okay.
And
Okay.
so I joined that and found that I was in the midst of 79 other lawyers who wanted to be plaintiffs' lawyers. And we started comparing notes and exchanging information and doing focus groups, actually. And that was the beginning.
So you were doing focus groups all the way back then?
I don't know that we call them focus groups. I think we were doing mini trials, and we didn't really take any measurements. We just practiced. We practiced a little bit on jury selection and opening statements, and mainly closing arguments. We were all big on doing closing arguments, and we realized finally that our closing arguments didn't really carry the day. We had to we had to learn to do a few other things.
So yeah, not to get too far off track, but tell me about that. I think when I started as a trial lawyer, I thought, oh man, closing argument. That's where, that's where you seal the deal and get everybody excited. And
That's where I shine.
yes,
That's my time.
right. And then when did you start to realize that maybe that wasn't nearly as important as we thought it was?
Probably after getting shellacked in the first trial. Then I realized that I had to look at things a little differently.
And tell me about that. What'd you look at differently?
Well, I paid more attention to the jury. That was the first thing. And jury selection wasn't my opportunity to get up and expound on myself and the trial and so forth. And I learned that I had to learn about the individual jurors. And that actually was pretty interesting.
That's stuff that we're talking about as we're trying lawsuits now, all the time, and some of it seems new and fresh now. I mean, you were doing this 40 years ago. Fair?
Well, yes, I guess we started then. Yeah.
So was that as we were doing a little background work on your career, Roger? We saw the Dalcon Shield IUD litigation. Can you tell us a little bit about that? How you got involved in that?
I got involved through some attorneys who needed someone to do research. So I started out doing legal research for some really pretty good lawyers. And I watched them handle their cases and put them together, and then ultimately had a couple of those cases myself. But I was not big in Dalcon Shield as handling the cases themselves.
Okay, and for our listeners at home, what was the Dalcon Shield?
It was an intrauterine device, and it was intended to prevent pregnancy.
Mm-hmm.
It was the predecessor to others, like subsequently I handled a number of copper 7 IUDs, and that was the beginning of the IUD business.
So, and were you trying those lawsuits just in Indiana, or were you trying them all over?
Ultimately, I had some out of state in Baltimore and Denver and um, Dayton. Um, can't remember if I was in Cleveland or not, but I had them in other states.
Talk to us a little bit about the differences in jurors and trying cases outside of Indiana as opposed to trying them here back home.
Well, you're warned and told that attitudes are different, so that you need to get in and really learn about how they think and how they do things in Baltimore versus Denver versus Brownstown, Indiana. And when you get into it, you realize that there isn't that much difference. And people are people. If you are honest with them and prepare thoroughly, and um, they're basically the same. I felt at home in Baltimore, for example.
Now,
Uh,
what did you try in Baltimore?
I think it was an IUD case,
Okay.
and we had a judge that was not fond of products liability cases.
That's
But
yeah. I've run into those judges before.
he was hooked finally, and he was a wonderful judge. But you just couldn't mess with him. You had to really
Yeah.
be prepared.
Oh yeah. What you said it made you felt at home up in Baltimore. What about it made you feel at home?
Probably the people I worked with, the attorneys, um, that brought me into the case initially. We had a good time. We were very comfortable together.
Have you found Indiana juries, as far as damages go, to be more conservative than the other states you've tried cases in?
Well, it depends. If you're trying a case in Columbus, Indiana, yes, they're more conservative. If you're in uh, East Chicago, they're not. But it depends, really, and they're pretty conservative in Indianapolis, depending on the court you're in and the who you happen to draw from.
I want you to kind of look back a little bit at when you started as a plaintiff's lawyer, and for our younger plaintiffs lawyers who are just getting started. What are some of the things that you wished, now that you know, obviously, that you wished you had somebody to tell you, this, that, and the other thing? What comes to mind?
Well, there are so many things. You have to really be prepared, so totally prepared. And that when I was prosecuting cases, they were duck soup by comparison. But a good products liability case or a good med mal case really requires thorough preparation. And if you're not thoroughly prepared, you're not going to be confident, and that's going to show, and the jury will sense that after you're in the courtroom, 2 or 3 hours.
Mm-hmm. Mm-hmm. Talk to us a little bit about ITLA. Do you remember when ITLA kind of got off the ground and got started?
Yes.
All right, tell me what you remember.
It was a relatively small group initially. I think there may be less than 100. And we were banding together because we were not a well-regarded minority. And we compared notes. There were some really good lawyers to start with. And I followed them around as best I could and chipped in some money so we finally we had a place to meet. And then finally we got the membership increased, and we went from 78 members to 300 or 400, 500 members, finally, 1,000+ members, and we could afford an office.
When did that happen, do you think? Are we talking 40 years ago?
Well, I think we got up to membership in excess of 1,000 in less than 10 years.
What is over the course of your career, what has ITLA meant for you, or how has it helped you along the way?
Well, it's an opportunity to associate with a tremendous group of people. Very, very talented. All had similar interests. It's like having a huge law firm. And invariably, they are very sharing. So you get briefs and pleadings and all kinds of research experts. It's just like having a big law firm.
And even though we're all kind of competing for the same, for the same cases, I've never felt that competition, and I've always just felt, like you said, I mean, you need anything, and someone will drop what they're doing and help you.
They will. It's amazing. We are competing in a way, but it's never a grudge fight.
Right, right. Can you? I was asking Amy before we met about some of your bigger cases, and I want to talk to you a little bit about the pesticide cases that you did 10 or that finished maybe 15 years ago.
Right.
Can you give us a little background on these cases and what they were about, and I know that it was like a 15-year saga almost.
It was.
Yeah. So tell us, not many of us have I don't know if you say pleasure or torture of a 15-year case, but tell us about that. So what was the chemical that was at issue? Do you remember that?
Yeah, chlorpyrifos.
And what did that do?
It was a neurotoxic, and it damaged the nervous system. And when it was exposed, when small children were exposed to it, they were particularly vulnerable. So if you'd spray it in the kitchen or in the house or someplace, they're crawling around. We quickly learned that they were just, in effect, scooping it up, getting it on their skin. If they would touch an appliance or a linoleum or something where it had been sprayed.
And what would you spray it for?
Bugs.
Oh, it's okay. It's
ants and
I gotcha.
Everything all the pests that come in the house and drive you crazy.
Yep.
Drive your wife crazy.
And so how did you tell me? I mean, so how did you figure out that it was tied to the pesticide?
We had some children who were injured, and by process of elimination, we found out that they were exposed to chemicals, and the chemicals were in the pesticides that had been sprayed in the home, and that's by process of elimination. We had some experts who helped us pin it down.
And how did it finally end?
Well, chlorpyrifos was taken off the market and banned. I think the pesticide litigation became more easily accomplished because there were causation experts finally that learned about this and were willing and ready and able and wanted to help. So we had a good group that put the litigation together, and it's still available. If anybody wants to get in that litigation and they have the right cases, the science is well developed and the experts are out there.
But the science was not well developed when you took the case, was it?
Well, it wasn't really all put together. And we had a toxicologist from Scotland, for example, 2 of them who were fantastic. They were great to work with. They were high energy people, and they did the research and they did the work and got it done. We found out that in Europe, they were fairly advanced compared to in the U.S. So they had literature over there that was available to us. We just didn't know enough to research it and look for it.
I've had a Scottish expert once too, and I found too that the jurors absolutely love the accent. It doesn't hurt.
That's right. It doesn't. If he has the personality to go with it,
that's right.
Great.
That's right. That's right. So why did it take 15 years?
I guess it takes time to go to the Supreme Court and back. I guess we went up there twice, maybe.
Oh my.
So it took a while to get the cases put together.
Mm-hmm.
And I don't know that it took 15 years, but it seems like that's ultimately how long we were at some of those cases.
Mm-hmm. And when was so there's people out there who are still trying those cases?
Yes.
That's fantastic.
I don't know if they have to try them now. They can settle them much more readily, but they're there to be tried. It's a matter of exposure, you know.
What do you mean?
Well, the cases are there, and if children are exposed, the chemicals are toxic, and we know enough now to look for it.
And so I know it's neurotoxin, it affects the brain, but what does that look like?
Well, it depends. It may look like seizures. It may look like hand tremors. It may look like inability to walk. So these little kids will manifest neurological injuries in every way you can imagine.
Okay. And as a part of and sort of as a result of your litigation and the litigation you were involved in, they ended up taking it off the market?
It was taken off the market sometime after I got out of that litigation. But people kept suing and going after chlorpyrifos, and it finally just became inevitable. It had to go.
Can you think of any cases that you were involved in that helped kind of change or shape Indiana law?
I guess the pesticide IUD cases would come as close as anything to develop a body of law. It didn't change it necessarily, but I don't think we had pesticide or IUD cases until those came along.
Yep. Something that I think is, I'm sure, dear to your heart as it is to mine. Talk to us about the importance of jury trials. Why are jury trials important?
That's how we govern ourselves. Ultimately, the law is decided by juries. It's, of course, passed by the legislature, and it becomes law, but it isn't really tested until it's tried in court. And it's tried in court most often, I think, by juries. The jury is said to be the conscience of the community. So if you have an issue that needs to be resolved, invariably, lawyers will want it resolved by a jury as opposed to just being resolved by one judge. And judges, frankly, will prefer for it to be resolved by juries as well.
Takes the pressure off of them.
Well, I think they recognize that there's benefit to a jury.
6 minds can sometimes come up with some better.
Or in the old days, 12.
Or in the old days, 12. That's right. That's right. And I've always seen juries as sort of one of the last checks between some of the terrible things that we've seen big companies do over the years in the name of profits and money. And is that sort of the experience that you've had as well?
Absolutely. That's it.
Yeah, it's one of those things where they can't donate money to a jury.
Right.
How over the arc of your career, how have jury trials, how did they change? How did you see them change? If at all?
Well, slowly, jurors are influenced by the media. And so if the media picks up some harangue about juries doing this or doing that or not doing it, it will influence some jurors for a while. But I think they all come back to being basically down the middle, wanting to do what's right. And if the case is presented to them in such a way that they have a choice, they'll do it.
And has that been your experience, that if it's presented in the right way, they'll reach the right result?
It is. And usually, hopefully, it's my result. Hopefully, I'm advocating for the right
That's right.
result.
It's tough to put food on the table if we're arguing for the wrong result.
That's right.
So what advice do you have for the young trial lawyer who's maybe joined ITLA and is maybe a little bit like you were before you joined the prosecutor's office, and hears people like you and some of our other guests, these giants of the courtroom, sort of talking about trials like their second nature? What advice do you have to these young young lawyers to get them into the courtroom and start working on that kind of stuff?
Well, first of all, you have to let other lawyers and people know that you're available, that you're willing to go to court, that you can stand up, and perform and do what needs to be done in court. Not everyone can.
Mm-hmm.
A lot of people would do everything they can to stay out of court. But if you're available and if you're willing to go to court, and if you do try cases, the word gets out. I tried a jury trial in the Justice of the Peace course. And they thought they could prevent this prosecution by requesting a trial by jury. And I was blowing it off, but the Justice of the Peace awarded a trial by jury. And so we went to Reddington, Indiana. He brought in a bunch of people. We picked a jury and tried the case.
What did you try it for? What do you remember? What it was?
I don't know. It's
something
that is
for the Justice of the Peace.
The Justice of the Peace, right.
And what advice do you have for sort of getting over that fear that there is of trying a lawsuit if you haven't done it before?
Well, you're not going to get over it. You're going to have that fear. And it's that anxiety that will make you prepare and will get you on your feet, in the courtroom. And if you can't do that, you just don't need that case. You need to send that case to some other lawyer.
What not just talking about jury trials, but what about the practice of law changed the most over the course of your career, and that just kind of shocked you?
Mm-hmm. Not sure how to answer that.
Probably because it was a poor question.
Well,
I'm in deposition mode, so I'm asking poor questions.
Well, it's not a poor question, but I have to think about it to come up with an answer for you. I don't have anything right off the top of my head.
Let me ask you this question from that just from my own education, being able to ask somebody like you. If you had your choice, would you prefer to try a case using technology, computers, PowerPoint presentations, things like that, or using boards, easels, chalkboards?
Well, when I started practicing, there were no computers.
Right.
So I'm not as adept at using them as some are. You have so much flexibility with the computer and PowerPoints and so forth. I'm of the old school, so I prefer the boards. I'm comfortable with that. I know that they're not the most efficient, but in some ways they are, because it's right there in front of them. You don't have to, you can just pull it up and put it on a stand and leave it there. It's a mixed bag, I guess. The the younger lawyers who grew up with computers and PowerPoints, I'm sure they're much, much more comfortable with that and much more proficient and efficient and do a better job with it than I do.
See, I think you're right on the boards, though. When you're when you're doing PowerPoint, things are moving, and so I feel like your attention is moving. But when you just have a static board there that has maybe two big arrows, and that's what they're staring at for 6 hours a day,
yes.
That's what gets burned into the front of their brain.
Well, you probably want a combination. You want the big boards, but then you want the other computer images that you can run through to get you from one board to the next or back to a board. So some combination is good.
If you had to think back, what as to the, and I know we just got done talking about the unimportance of closing arguments, but if you can think back, there is still something kind of romantic about a good closing argument. When you think back over all the arguments you've given, is there any that sort of stand out as one that you were proud of?
Well, I don't know that there is one particularly that I'm proud of, but I do think that it's so important to have a closing argument and be able to pull together the loose ends that were developed and that are out there from the trial. And if you can do that and present it in a cohesive statement to the jury, they'll go, it's a story then that they learn, and it sticks with them.
So, Roger, we've been talking throughout this podcast or this episode about changes you've seen over the course of your career. One of the things that I think changed in the middle of your career was this presumption under Indiana's product liability law. And that was a presumption that the jury gets, if something meets federal regulations, then the jury gets to presume that the product is not defective.
Right.
What would in trying a case with that type of presumption, what would you tell a younger lawyer? How would you argue that to the jury? Now that we have to deal with this presumption that the jury is going to get an instruction that says this product is presumed to be not defective. So you're at trial. You've already got past summary judgment. How do you argue? What argument do you make?
I don't know specifically off the top of my head, but it's obviously a question of fact as to whether or not something is defective. So you marshal your evidence and you present everything that you think supports that claim, and then you match that up against the written presumption, and the presumption just fades away. It fails.
The presumption is there if there's no evidence. But once you have evidence that shows that the presumption's not there, it should just drift away.
Yeah, yes, and you have to present more than just a little bit of evidence.
Sure.
You have to present sufficient evidence to overcome, in my mind, and your mind, and the jurors' minds, that it's presumed to be safe.
Right. Now, Roger, I feel somewhat humbled to be in the presence of somebody who is a member of the inner circle of advocates. For the uninitiated, tell us what the inner circle of advocates is.
Well, it's 100 lawyers in the country who specialize in personal injury litigation, and it's selected by other lawyers in the country. I was the first lawyer from Indiana to be a member of the inner circle. I think there's one other now,
Lance.
And it's a group that generally consists of those who have made some extraordinary contribution or accomplishment in personal injury litigation. And I go to those meetings and listen to those fellows talk about their accomplishments, and I'm blown away. They do things in California and New York that we don't accomplish very often in Indiana. But that's what it is. It's just a group of specialists in personal injury litigation, and it's a big family. Everybody shares information, sends sends it back and forth, you know.
Yeah. What was the big? I know you don't like talking about yourself. But what was the big contribution, or that got you into the inner circle?
I had a couple of cases that were unusual, and one was a verdict that was unusual for Indiana, I think, and that got somebody's attention, and I was recommended and got in.
And how long ago was that?
I think it was in '95.
Okay. Okay.
Not sure, I believe that's right.
Now I remember something I wanted to ask you, Roger. I'm glad we're back on tape. So Amy told us once that you would sometimes walk around the law office and ask for sort of the hardest case, or the case that's been sitting there the longest, and to try and then work that case up like crazy and take it to trial. Was that an old habit of yours?
If she remembers it, then yes, I guess it was. I do remember that on occasion. That happened, yes.
Okay.
Those cases are more fun.
Why are they more fun?
Well, the challenge is there, and you're invariably involved with some intricate aspect of the law or of science or medicine, you know, something that takes some digging.
Mm-hmm. Mm-hmm. Yeah, I find I find the same thing in those in the cases that are hard like that.
Yeah.
Yep. Well, Roger, it's been an absolute pleasure talking with you this afternoon. Thank you for inviting us into your home and giving us time to speak with a legal legend of the Hoosier State.
It's been my pleasure having you. I enjoyed it.
Awesome.